Hi, my name is Gagandeep Randhawa and my student ID is AC8392.
And my name is Arpana Ranabhat. My student ID is EMV80159.
And today we're gonna represent our report we made on Shafron v ASIC 2012. In their case, Mr. Shafron, he was employed by Jamie Hardy's group of companies in 1988 as a general counsel and company secretary. It has been found that he has been failed to provide any sort of advice to chief financial officer and justify his role by providing advices to the CFO and CEO. But when he has been appeared to the court, he asked the court to consider three questions. The first, in what respect the statutory definition of officer applies to him? Did he fail to exercise the relevant standard of care by failing to advise the CEO or the board that the DOCI information should be disclosed, thus ASIC? Did he fail to exercise the relevant standard of care by failing to advise the board that the actual material did not take account of superimposed inflation but should have? So, but the court found that according the section 180 implies to him, which shows that the directors and other officers of the corporation must exercise their powers and discharge their duties with a degree of care and diligence that a reasonable person would exercise if they were a director or officer of a corporation in the corporation circumstances, or either they are occupied the office held by and the same responsibilities with the corporation. As to the first point, it was not disputed that Mr. Shafron was an officer of JHIL by virtue of Section 9A of the Act, which specifies that a company secretary definition of an officer. Mr. Shafron, he tried to convince the court and tried to make an appeal to the court that he expected that he has breached the Section 180, but he tried to alleged against him was concerned with actions he made in capacity as a general counsel and not his capacity as officer of James Hardy Group of Companies. But the court, he rejected following submissions which were uh, that whilst the High Court expected that Mr. Shafron has currently identified that the question of a company secretary's responsibility is a matter of fact, but the High Court did not agree that Mr. Shafron's responsibilities as a company secretary be defined by references to those of Mr. Cameron, his co-secretary, whose role was purely administrative. And later, the court tried to provide the definition of an officer, which will be explained further by my partner, Arpana Ranabhat.
It is of assistance to determine how a reasonable person occupying the same office and having the same responsibilities would exercise the powers and discharge their duties. Thus, importing an objective test should be directed to the role an individual plays, generally with the corporation, not simply the role the person has played in relation to the particular issue in respect of which it is alleged there has been a breach of duty, although that could also be relevant. General Counsel and Company Secretary indicated that an important part of Mr. Saffron's responsibility was to take the steps necessary to ensure JHIL complied with all relevant legislative requirements, including those that applied to JHIL as a listed company, and that this extended to the provision of necessary advice. That's it.
Come on.
As such, the court dismissed the appeal, agreeing that a company secretary with a legal background would be expected to raise issues such as potential misleading statements in disclosure obligations, and that because of Mr. Saffron's close involvement in the expected to raise issues such as potential misleading statements in disclosure obligations, and that because of Mr. Saffron's close involvement in the actuary advice, including sourcing it and pitching it to the board, the raising of the limitations of that advice was a responsibility that fell within Mr. Saffron's responsibility as company secretary. Company secretaries with a legal background should also take note that they ought not blindly rely on advice sourced from third parties, legal advice but also accounting advice, and should ensure that the board is warned of the limits that advice may have. The decisions to help clarify the duties of non-executive directors and management below board level. Importantly, the High Court has reinforced the application of an objective standard of diligence for directors and officers of companies. The ramification from the viewpoint of a corporation, it is important that client includes a person who employs a lawyer including under. So the conclusion has a press statement welcoming these decisions, stating that they reinforce the behavior expected of gatekeepers in our markets, such as directors, and hailing them as already shaping corporate behavior and having a positive effect. Whether this is the case remains to be seen, but we certainly agree that the decisions to help clarify the duties of non-executive directors and management below board level. Importantly, the High Court has reinforced the application of an objective standard of diligence for directors and officers of companies.